All right, good morning, everyone. I'm going to call to order the Code Enforcement Magistrate hearing for Martin County for September 18th, September 18th. I'm reading September 18th. It's October, of course, and then it's the 16th, so 2024. If you'll please rise, join me in the Pledge of Allegiance. I pledge allegiance to the flag of the
United States of America,
and
to the republic for which it stands for
one nation.
under God, indivisible, with liberty and justice for all.
Okay, thank you. Be seated. I understand we've got one of the parties here this morning, and I'm going to take that case first. It's at the bottom of the first page of the docket. It's case ENF 2024 090258, and the respondents are Jolene Jensen and Mark Diwali. And Ms. Espiat, you're going to testify. I'm going to swear you in. If you'll raise your right hand, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And I'm going to actually swear you in up here later. What we're going to do is, and if you want to either come up and stand at the podium or watch this monitor up top, you can sit and just watch the monitor if you like. The county's going to present evidence. They're going to tell basically their side of the story. If they follow basically the script and make what the law calls a prima facie case, that is, if everything they present is correct and accurate, then I can find a violation does exist. If that happens, then I'm going to ask you to explain, to present whatever evidence you want to present, ask any questions of the county that you may have, and then we'll go from there. And then I'll decide the case and let you know where we are. This is a violation case, and it's a violation as the county charged of Section 105.1 of the Florida Building Code, meaning that the county believes you did something without a necessary permit. And so we're gonna hear from the county. Officer Espiat's going to testify, and then the burden then will kind of flip to you, and then we'll go from there. Okay, so let's hear from the county, and good morning, Officer Espiat.
Good morning. My name is Maria Espiat, and I have been sworn in. I'm a code compliance investigator for Martin County. The respondents, Jolene Jensen and Mark Diwali, are present. This case concerns a property at 1105 Northeast Exora Drive in Jensen Beach, Florida, and Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owners are Jolene Jensen and Mark Diwali. A copy of the property appraiser's record of ownership is County's Exhibit 1. On September 19, 2024, I left a door tag for an expired permit application, BLD 2018-071-527 for an AC, and an expired permit, BLD 2023-050-256 for a concrete deck. The door tag is marked as County's Exhibit 2. Nuisance Abatement Coordinator Rachel Spradley called the homeowner to explain the violation. However, the homeowner emailed us back and made it clear she did not want to discuss the matter by phone and preferred email. On October 1st, 2024, there were emails between our department and the owner where she didn't want to acknowledge that the permit for the AC was never issued. On this email, she states that the work was already done, making the AC an unpermitted AC. The concrete deck was no longer an issue, and it was closed out. The email is marked as County's Exhibit 3.
Okay.
The permit history is marked as County's Exhibit 4. This is where the AC is not issued. And there's no other AC permit.
So, wait a minute, let me understand. They had applied for an AC permit. Is that correct?
Correct.
And then it says waiting on applicant.
Meaning there's some kind of documents missing in order to have it issued. The county is,
May I make a correction?
No, not yet, sorry. Don't say anything until I swear you in, and we'll go from there. So let me just ask you, did you then look to see what the county was waiting for, the building department, or no?
no,
Okay, so you just take at face value what that is, okay, go ahead.
correct.
Go ahead.
Due to the circumstances, I issued a notice of violation to the owners on October 1st, 2024, marked as County's Exhibit 5. In the notice, I cited the following Martin County Code violation: Section 105.1, permits when required, incorporated by Section 21.1, General Ordinances, Martin County Code. In the notice of violation, the respondents were given until October 16, 2024, to correct the violation, and were informed of the need to contact Martin County Code Enforcement upon doing so. The notice of hearing was also sent out the same day by certified mail and regular mail on October 1st, 2024, as well as posted at the property and the Martin County Admin Building. The notice of hearing and affidavit of posting are marked as County's Exhibits 6 and 7. 6 is a notice of hearing. 7 is the affidavit of posting. Since then, no call or letter from the property owner was received within the time allowed. On October 15, 2024, I checked the permit status, and it still has not been issued. The permit status is marked as County's Exhibit 8, where it's highlighted, waiting on applicant still. Based upon the testimony and evidence, I request that the respondents be ordered to comply with the cited provisions of the Martin County Code by January 12, 2025, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violations continue thereafter. The county has incurred a cost in the amount of $575 conducting this investigation, and request that the county be reimbursed this amount at the conclusion of today's hearing.
Okay, all right. If you will, whoever, if you're both going to speak, then let's have you raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
And ma'am, your name?
Jolynn Jensen?
Okay, and sir? Okay, great. Okay, so and you're the owners of the property. Okay, terrific. Well, you've heard the county. You've seen now the evidence that they have to present. Looks like the main thing has to do with this AC permit that the county, at least their website says, never really got issued back in July of 2018. And so what do you know about it, and what can you tell me?
So, first of all, the first notification we ever had of that violation was on 9/19/24 when this notice was posted
Okay,
on our door.
Mhm.
It said concrete deck and AC application.
Okay.
Well, the concrete deck issue goes back to last year when we had 2 patio pads installed in our backyard.
okay, but that's not an issue today.
No.
The
Not
county's,
today, but I have a whole slew of emails
Mhm.
to clear it up.
and you did,
And, well, no, the county cleared it up. Somebody had forgotten to check off a box
Okay.
saying that the foam core survey was received.
okay,
Okay,
good,
so we cleared that one up with emails.
yes ma'am.
Then I had no idea what they were talking about for this AC because we had just moved in May of 2018. We had all new electric put in and an AC unit by Elite Electric in July.
Okay,
We paid them almost $20,000 to do the work, and it included the permits.
and this was when?
That was July of 2018.
Okay,
So we have gotten a number of permits and even one violation back in January, which we cleared up, and I have an email from Andrew Brune saying, yes, that was completed. So we had no idea there was any other problem. So then when I got this, I sent off an email to Maria, and I'm like, this was closed out. This concrete deck was closed out. I've got an email from Andrew. And what's the AC for? So 6 years later, we receive a notice that it's not closed out. Okay, since that time, we've done the research. We contacted Elite Electric.
Okay.
On the 9th of October, Elite Electric filed the permit extension request
9th of which October?
this year, 10/9/24. I have a copy of the extension request
Okay,
and the email that Connie DeWitt, the permit manager for Elite Electric, sent to Andrew Brune with the county, asking what's going on, why was this not approved? And so he said, you have to fill out this form. So the same day, she filled out this form and submitted it to the county.
she being Elite Electric, person?
Permit manager, correct.
okay?
Connie DeWitt. So this form is filled out, submitted to Martin County on October 9th, 24. Now, it does state, please be advised, that extensions and renewals can take 7 to 10 business days to be approved.
Okay.
So that may be why it's not in the system. But we actually did not receive this notice about this violation until the 8th of October, when we signed for it at the post office,
Okay.
because we were in Texas and Louisiana visiting children and grandchildren.
Okay.
So we did not receive what was taped to our door. We did not receive anything in the mail because the post office was holding our mail.
Okay,
My
but you're,
husband
but
went
you're
on
here
faith
and,
signed it.
so you've
So
gotten notice.
Immediately, we called Elite Electric. They got back to us the very next day with the answer, because they had to dig through 6 years worth of files. Luckily, we chose a company that's still in business, and I had my files. I've still got the permit signed, but it was, as I look, it was only the electrical permit that was signed off on for all the work that Elite did.
Okay,
They did a whole change out of our electricity, plus installed air conditioning, because our house had never been air conditioned. So at this point, I mean, I feel like I have done a lot of emails. We've contacted Elite. I'm not ignoring this. I had no idea. If somebody
Okay.
had told us 5 years ago there was a problem, I would have dealt with it.
sure.
4 years ago, back in January, when Nancy came out and gave us a notice that our concrete deck was not taken care of, I immediately called Andrew
Okay.
and then sent him an email as he requested. At which point, he immediately responded back the next day, "Good morning, I reviewed the file and you're correct. This permit is closed complete. Any further issues, please let me know."
All right, but that's not an
Right.
issue today. You did exactly what you should have done in that case, and
Yes.
that's great. As far as that Elite extension request, if the county has not seen that, I'm going to ask you to show that to
Your
the
Honor,
county.
the issue is that it was an application that was expired.
Okay.
That only renews the application.
Yes.
It's still not an issued permit.
Well, it sounds like it hasn't even renewed it yet.
It is renewed. That's why it's
Oh, it
waiting
is.
on applicant and not showing expired anymore.
Okay.
Your Honor,
So,
if I can just maybe clear it up a little bit.
Yes.
The county will stipulate the renewal application was put in.
Okay,
They were granted
good.
a 3-month extension to
Okay.
complete the application to get the permit. That's why, if you note, the compliance date on this case
Is
goes out
beyond
to,
that.
it gives them, instead of the usual 30 days, it's extended out to the 90 days that the permitted extension gives.
okay. This is an unusual situation, and usually folks that come up here are not as well organized as you are, which is really good. It's good for you and actually good for the county as well. Why it didn't get closed out at the time, of course, none of us are really going to know, because the folks that were doing all of that at the county probably aren't there any longer, but it doesn't matter. And I do understand, it's not unusual to have a permit not get closed out, and then somebody has to go back later and look at it and figure that out. So what I'm going to do is I'm going to find that, based upon the evidence, your testimony and the county's plus the evidence presented, and I am going to accept into evidence I'm sure you don't really have any objection. The county's exhibits 1 through 8, I'll accept those into evidence, unless there is an objection. And based upon all of that, I'm going to find that technically the violation does exist. The permit never got closed out, and it perhaps should have been, but it could have been anything. I don't know. Do you remember whether you paid for the permit at the time?
Yeah.
Okay, so it's already paid for, and they're waiting for some bit of information, whatever that turns out to be, maybe. But be that as it may, what the county is saying is they are willing to give you enough time to more than cover the 3 months period, I guess. Let's see, where are we? It's October 16th, so November, December, January 16th. This actually, their request was for the 12th. I'm going to go out even beyond that and give you that much time to clear this all up. And that should take care of the issue. And based on the circumstance, I don't think it's reasonable necessarily to even exact costs in this case. I just don't see it. It sounds to me like,
Well, Your Honor, we did offer us the opposite of a stip to avoid that, and it was declined by the respondent.
I was never given any opportunity to
did you-
stipulate to anything.
They never communicated back to us.
Oh, okay, so we never got an answer back on the offer.
okay, all right.
was never-
I'm gonna not award costs in this case. I think I'm gonna give you until January. Let me look at my calendar and just see what's a good date in January. All right, I'm going to give you until January 24th, which is a Friday, to cure this. Failing which, there will be a fine in the amount of $100 a day if you don't get it fixed by that time. But I'm not going to award costs to the county in this case. I think it's unusual enough. You're well organized. You know exactly what occurred, which is surprising because most people would not be able to recall that 6 years later. So, all right. So, let's see.
I want to be clear on one thing.
Yes, go ahead.
So the county did receive this renewal request from Elite?
Correct, and that's why the status is showing waiting on applicant, meaning Elite needs to provide the documents
Okay,
necessary.
what status and where? I haven't received anything back from the county after the notice to appear here in court. I haven't received anything back, not an email, not a document, nothing. How am I to know that this was actually received by the county and the status changed?
I would recommend you call your contractor, but your contractor needs to submit to the county the right
I
documents.
know
And
exactly what the contractor needs
Okay.
to do.
Whoop,
This is
whoop, wait a
what
minute.
the contractor did.
Hang on just a second. Normally, I don't allow you just to have a conversation between each other. You usually have to go through me, but I was writing the order in this case. If you have questions regarding what the contractor needs to do, it would be appropriate for you to first start with your contractor, make sure they understand what they are supposed to do. If they do not, then one of you either, and I would make the contractor do this, contact the county and find out, because it is, after all, still technically their permit.
Right.
Yes, it affects you because you're the property owner, but they have an open permit. It's been paid for. You as a homeowner want to be able to understand from them why they're deficient and where they're deficient, and make sure that they take care of it. I mean, you've paid for it, so
Yes.
make sure that they do what they're supposed to do.
Your Honor, if I could just offer a correction, there is no open permit on this. It's an application. A permit was never issued. All they did was put an application in 2018, never submit any of the documents. So they need to submit the documents, get the permit issued, and then get it closed out.
Okay, all right. So you understand what county attorney's telling you, and that is that no permit was ever issued. should have been, and maybe it's Elite's fault. We don't know.
It appears that documents were submitted, but the county came back with some changes that needed to be made in the permit. And Elite shows that they sent those corrections on 9/7/2018, but that it hadn't been reviewed by the county.
Okay,
Andrew stated that the permit by that time was already expired. And so they did not review the new drawings. So I know what needs to happen. My question is, how can I go on the county website or wherever
And
to
see
see
that?
that this status has now been changed to in process?
Yeah, I don't know that you can directly. They can't access the Excel program, so how does somebody find that out?
We can explain that to her after.
Okay, good. All right, so
Okay.
after the hearing, we'll make sure that you get a copy of the order and hopefully get it all cleared up and everybody goes about their business.
Hopefully within the next month, we'll have it cleared up.
Good, great. All right, good luck to
Thank
you.
you.
Yes, ma'am. All right, let's see, we're gonna go back up to the top of the, well, let's see, you've got one more case?
I'm stepping in for Christopher
Oh,
Counselor.
you are, okay,
Yes.
and that's in the TPC case? The first case on the docket?
Correct.
Okay, all right, so, I'll call that one, it's ENF 2023-100476, and it's, respondent is TPC St. Lucie Green Ridge LLC, and Ms. Espion, you're gonna, testify in this case, let me just make sure I've got you down there. Okay, very good. And you've already been sworn in. Go ahead, whenever you're ready.
My name is Maria Espiat, and I have been sworn in. I'm a code compliance investigator for Martin County. The respondents, TPC St. Lucie Green Ridge LLC, have entered into a stipulation agreement, and they are not present. This case concerns a property at 10275 Southwest Green Ridge Lane, Palm City, Florida, Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owners are TPC St. Lucie Green Ridge LLC. A copy of the property appraiser's record of ownership is County's Exhibit 1.
Okay?
On October 30th, 2023, Officer Benjamin Norman inspected the property for an expired permit application, BLD 2023-010350, which was for a remodel. At that time, he photographed the property. The photograph accurately shows what he saw then and is marked as County's Exhibit 2, the expired permit application letter.
Okay.
Exhibit
Yep.
3
Yeah, go ahead.
is the actual property. 4, I guess he's showing that he was in the right location. And 5, a different angle of the property. Based upon the investigation, Officer Norman issued a notice of violation to TPC St. Lucie Green Ridge LLC on November 21st, 2023, marked as County's Exhibit 6. In the notice, he cited the following Martin County Code violation. Section 105.1, permits when required, incorporated by Section 21.1, General Ordinances, Martin County Code. In the notice of violation, the respondent was given until December 21st, 2023 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. On April 2024, Officer Frank Marcos took over the case. The property was still in violation and had no permits issued for the remodel work. So Officer Marcos sent a notice of hearing by certified mail on April 17th, 2024, for the May 2024 hearing and is marked as County's Exhibit 7. The case was given an extension and removed from the May docket. Officer Counselor took over the case in August of 2024. He spoke to the property owner and discussed the violation and what needed to be corrected. A permit BLD 2024-041-727 for the AC work that was done as part of the remodel was issued on May 2nd, 2024, and finalized on September 17, 2024. The permit application, BLD 2023-010-350, has not been issued. A new permit for the remodel work started on June 28, 2024, BLD 2024-061-649, which has conditions that are preventing it from being approved. The permit status is County's Exhibit Number 8. Since compliance was not achieved, he sent an amended notice of hearing by certified mail October 1st, 2024, marked as County's Exhibit 9. The return receipt was not received, so on October 3rd, 2024, he posted the property. A photo of the posting and the affidavit of posting are marked as County's Exhibits 10 and 11. 10 he posted at the property, and 11 is his affidavit. On October 14, 2024, Officer Counselor spoke with the representative of the property, and they agreed to enter into stipulation agreement for more time. The payment that was agreed upon, $350, was made on October 14, 2024. I request that all of the county's exhibits be received into evidence. This concludes my testimony.
All righty. Okay, let's see what we've got here. All right, so looking at the stipulation, I find that it does require that they obtain their permit by January 1st, 2025. And in the event that they don't do that, it calls for a fine of $100 per day, and that $350 has been paid to the county in costs. And the stipulation is signed by Carl Allegretti on behalf of TPC St. Lucie Green Ridge LLC, and Officer Counselor on behalf of the county. And do I understand you've actually been out and visited this property, is that correct?
Yes, I've been out with Mr. Counselor.
Okay, and so you are aware of the violation of the section 105.1. What work did they actually start to do?
I haven't seen the prior pictures. I was just out for the day before.
Okay, all right. All right, okay, so, and without objection, I'm going to accept into evidence the county's exhibits 1 through 11 in the case. Based upon the stipulation and your testimony, I'm going to find that it is appropriate to execute the agreed final order in this case. And hopefully they will get whatever permit situation squared away. And thank you. That's that one. You've got more. You're going to do all of Officer Counselor's cases
One
this
more.
morning? Okay. All right, so the next case is ENF 2024-060637-01. Respondent is Kimberly Hatcher. And what have we got here? Yep, go ahead.
My name is Maria Espaya, and I have been sworn in. I'm a code of compliance investigator for Martin County. The respondent, Kimberly Hatcher, is not present. This case concerns a property at 2928 Southeast Fairmont Street in Stuart, Florida, and Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Kimberly Hatcher. A copy of the property appraiser's record of ownership is County's Exhibit 1. On July 9th, 2024, Officer Counselor inspected the property. At that time, he observed high grass. At that time, he photographed the property. The photographs accurately show what he saw then and are marked as County's Exhibits 2, 3, and 4. This is the property, high grass on the left. A different view of the high grass, and number 4 is on the right side of the property, high grass.
Okay.
Based upon the investigation, he issued a notice of violation to the owner on August 1st, 2024, marked as County's Exhibit 5. In the notice, he cited the following Martin County Code violations: Section 67.201, nuisance declared, weeds, undergrowth, general ordinances, Martin County Code. In the notice of violation, that respondent was given until August 15, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on September 26, 2024, and is marked as County's Exhibit 6. The return receipt was not received, so on October 3rd, 2024, he posted the property. A photo of the posting and the affidavit of posting are marked as County's Exhibits 7 and 8. 7, he hung the notice here at the property. 8 is the affidavit of posting. Therefore, I myself went again to the property on October 15, 2024, and saw that the cited violation had not been corrected. At that time, I photographed the property. The photograph accurately show what I saw then and are marked as County's Exhibits 9, 10, 11, and 12. 9 is the left side, including the high grass in the back. 10, more of the center, a different angle, and 12 is the right. I requested all of the county's exhibits be received into evidence. Based upon my testimony and evidence, I request that the respondent be ordered to comply with the cited provisions of the Martin County Code by November 29th, 2024, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violations continue thereafter. The county has incurred a cost in the amount of $575 conducting this investigation, and request that the county be reimbursed this amount at the conclusion of today's hearing.
Okay, anybody here on behalf of Kimberly Hatcher? Looking out, seeing no one. Without objection, I'll accept into evidence the county's exhibits 1 through 12 in this case. Based upon that evidence and your testimony, I will find that violation as charged does exist on the property and order compliance on or before November 29th, 2024, failing which a fine in the amount of $100 per day will accrue. And I'll further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing.
Thank you.
Okay. Let me just ask before you get started, Ms. Switzer.
Yes.
Officer Espionette, have you got one more case, the Melissy case?
Yes.
Let's do that one first, and then we can excuse you. All right, let me dig that one out. Okay. All right, so this is case number ENF 2024-080046. Robert J. and Janet Melissy are the respondents, and you've been sworn in, and whenever you're ready.
My name is Maria Espia, and I have been sworn in. I'm a code compliance investigator for Martin County. The respondents, Robert J. Melissy Jr. and Janet Melissy, are not present. This case concerns a property at 2458 Northeast Wilda Street in Jensen Beach, Florida, and Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owners are Robert J. Melissy Jr. and Janet Melissy. A copy of the property appraiser's record of ownership is County's Exhibit 1. On August 1st, 2024, I inspected the property. At that time, I observed high grass on a vacant lot. At that time, I photographed the property. The photograph accurately shows what I saw then and is marked as County's Exhibit 2. This is a vacant lot with the high grass. Based on my investigation, I issued a notice of violation to the owner on August 8th, 2024, marked as County's Exhibit 3. In the notice, I cited the following Martin County Code violation. Section 67201.A, nuisance declared weeds, undergrowth, general ordinances, Martin County Code. In the notice of violation, the respondents were given until August 21st, 2024 to correct the violation and were informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on September 20th, 2024, and is marked as County's Exhibit 4. The return receipt was not received. Therefore, on October 1st, I posted the Martin County Admin Building and the property. The affidavit of posting is marked as County's Exhibit 5. No call or letter from the property owner was received within the time allowed. Therefore, I went again to the property on October 15, 2024, and saw that the cited violation had not been corrected. At that time, I photographed the property. The photograph accurately shows what I saw then and is marked as County's Exhibit 6.
Okay.
I requested all of the county's exhibits be received into evidence. Based upon the testimony and evidence, I requested that respondents be ordered to comply with the cited provisions of the Martin County Code by November 29, 2024, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violations continue thereafter. The county has incurred a cost in the amount of $575 conducting this investigation and requested the county be reimbursed this amount at the conclusion of today's hearing.
Okay, anybody here on behalf of Robert or Janet Melissi? Looking out, seeing no one. Without objection, I'll accept into evidence the county's exhibits 1 through 6 in this case. Based upon that evidence and your testimony, I'm going to find that violation as charged does exist on the property and order compliance on or before November 29th, 2024, failing which a fine in the amount of $100 per day will accrue, and I'll further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing.
Thank you.
Okay. All righty. Now, Ms. Switzer, good morning.
Good morning.
If you'll raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Great. Good morning. Again. Let's see. We've got case ENF 2023-090314, and the respondent is Lisa Copeland. And whenever you are ready.
Okay. My name is Kelly Switzer, and I've been sworn in. I'm a code compliance investigator for Martin County. The respondent, Lisa Copeland, is not present. This case concerns a property on a vacant lot in Palm City, Florida, 34990. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Lisa Copeland. A copy of the property appraiser's record of ownership is County's Exhibit 1. On September 14th, 2023, I inspected the property. At the time, I observed trash and debris along the vacant lot spilling into Martin County's right-of-way. At the time I photographed the property, the photographs accurately show what I saw then and is marked as County's Exhibits 2 through 4.
Now, what am I looking at there?
So these are basically pilings that are laying on the roadway, on his property. These are pallets full of, I guess, pavers, building materials.
Okay.
Here's another angle of the pilings. And then this is an aerial. This is the county right-of-way. The red is his property in question.
Oh. Well, that's interesting. Yeah, okay.
A follow-up inspection was conducted on May 16th, 2024. The follow-up inspections are photos are marked as County's Exhibits 5 and 6. There's some more pilings. Just another angle of all the debris. Based upon the investigation, I issued a notice of violation to Lisa Copeland on June 25th, 2024. In the notice of violation, The notice of violation is marked as County's Exhibit 7. In the notice, I cited the following Martin County Code violations: Section 67.201B, nuisance declared trash, etc., general ordinances, Martin County Code. In the notice of violation, the respondent was given until July 16, 2024, to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. The owner's boyfriend started to remove some of the pilings and was granted more time to comply. Therefore, it was removed from the September hearing. An amended notice to appear was sent on September 19, 2024. The amended notice to appear is marked as County's Exhibit 8. The return receipt was not received. Therefore, I posted the property and at the Martin County Administrative Building. The posting and the affidavit of posting are marked as County's Exhibits 9 and 10. This posting and my affidavit. No call or letter from the property owner was received within the time allowed. Therefore, I went to the property again on October 16, 2024, and saw the cited violation had not been corrected. At that time, I photographed the property. The photograph accurately shows what I saw then and is marked as County's Exhibits 11 and 12. Now there's a car there, and that's still the pavers on site.
And that's all within the right-of-way,
Some's in the right-of-way, some's on his property.
okay? Or her.
There's some pilings in the back. Let me zoom in a little. There's the pilings over here. I request that all the county's exhibits be received into evidence, and based upon the testimony of evidence, I request that the respondent, Lisa Copeland, be ordered to comply with the cited provisions of the Martin County Code by November 29, 2024, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violation continues thereafter. The county has incurred a cost in the amount of $575 conducting this investigation, and requests that the county be reimbursed this amount at the conclusion of today's hearing. This concludes my testimony.
Anybody here on behalf of Lisa Copeland? Looking out, seeing no one. I guess my question is, do we know what it is they're trying to accomplish here?
I believe they're trying to replace the dock on the property.
Okay, is there an active permit? Or?
No, there is no permits active at this time.
Okay, all right. So,
Could I comment on that, please?
sure, Mr. Darney, thank you. Good morning. You'll raise your right hand. Do you swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And your full name and position?
Jeffrey Patrick Doherty, Director of the Building Department, which oversees code enforcement. To answer your question, this particular property all along the water line is very unique. It was platted over 100 years ago when it was Palm Beach County, and ultimately was under the jurisdiction of Palm City when it was incorporated.
Okay,
Over the recent years, recent being 70s and 80s, land accreted along the waterway, and it was debated as to who had riparian rights to build docks. Ultimately, it ended up in a lawsuit about 10 years ago. And through the judicial process, it was deemed that the accretion was the adjacent upland owner, even though there was a right-of-way in between. This land is part of the accretion that went beyond the right-of-way, so that's why it's a very unique shape.
Oh.
Originally, the accretion included right-of-way, but the county ultimately abandoned it in the 40s or 50s, but it is not a buildable lot of record. You're only allowed to have a dock if you have a buildable lot of record that you can build a primary structure on. So that's been the debate back and forth as to
if
why.
you will, pull up Exhibit 4, and maybe, Mr. Doherty, you can explain how the county would have a piece of property in what looks like in the middle of private property.
Well, the right-of-way is running left to right on this picture. You can see the roadway at the very bottom of the picture.
Yes.
And the land north or to the top of the paper is all accreted land.
Okay.
And the right-of-way, in the area in red, if you go straight down, is another right-of-way that runs 90 degrees to the one across the top. So it was a continuation of that property out into the water via accretion.
Gotcha.
The right-of-way benefits stayed with the accretion. But either left and right, the land benefited to the fee owner on the other side of the right-of-way, because the fee to the right-of-way was always retained by the property owner.
Okay. Looks like there's a dock existing, or part of a dock existing with some boats at the very top of the photo.
There was a dock built, it was never permitted. And
Okay.
this goes back to the 80s, to the best of our knowledge.
All right. So, well, that's, well, interesting. Thanks.
It's a very complex issue.
It will be, it sounds like, for both the county and for,
Yes. All the other docks that abut the accreted land were via the judicial decision, they were fee simple owners and therefore entitled to riparian rights, which was an extension of their existing platted lotted record on the other side of the right-of-way. This, however, is a very unique situation.
all right. Is it under appeal, do you know?
There's no formal appeal.
There's, okay, so it's done. All right,
That's to answer the history of it.
okay. All right, let's see, wherever I was, I'm gonna probably start over. So based upon the testimony, now that I've heard in the evidence, and I'm gonna find that a violation as charged does exist and order compliance owner before November 29th, 2024, failing which a fine in the amount of $100 per day will accrue. I am going to award costs in the amount of $575 to be paid to the county at the conclusion of this hearing. Okay. All right, let's see, we've got the Speakman case.
Yes.
This is case ENF 2024-070619-01, and respondent is Holly A. Speakman. Whenever you're ready.
My name is Kelly Switzer, and I've been sworn in. I'm a code compliance investigator for Martin County. The respondent, Holly A. Speakman, is not present. This case concerns a property at 4440 Southeast Chesapeake Bay Drive, Stuart, Florida 34997. This case was not generated from an anonymous complaint. According to the official records of the property appraiser, the property owner is Holly A. Speakman. A copy of the property appraiser's record of ownership is County's Exhibit 1. On July 26, 2024, I inspected the property based on a complaint we received stating that the property had trash and debris along with inoperable vehicles. At the time I photographed the property, the photograph accurately shows what I saw then and is marked as County's Exhibits 2 through 4. There's trash over here. Just another angle. Another close-up. The inoperable vehicle is actually going to be in my next exhibits. Based upon the investigation, I issued a notice of violation to Holly A. Speakman on August 27, 2024. The notice of violation is marked as County's Exhibit 5. In the notice, I cited the following Martin County Code violations: Section 67.201B, nuisance declared, trash, etc., General Ordinances, Martin County Code. Section 91.34A, generally inoperable vehicles, General Ordinances, Martin County Code. And Section 67.201A, nuisance declared weeds, undergrowth, General Ordinances, Martin County Code, which that code is now in compliance. In the notice of violation, the respondent was given until September 17th to correct the violation and was informed the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved. A notice of hearing was issued by certified mail on September 27th and is marked as County's Exhibit 6. The return receipt was not received, therefore I posted the property and at the Martin County Administrative Building. The posting and the affidavit of posting is marked as County's Exhibits 7 and 8. My posting, my affidavit of posting. At the time of posting, I also conducted a follow-up inspection. The exhibits from my follow-up are marked as County's Exhibits 9 through 11. So there's inoperable vehicle, flat tire. There's more tires, trash and debris on the side of the house. There's trash by the front door,
Okay, we're now looking at 11.
11, yes.
Okay.
And 12 is just another, that was tomorrow, yesterday. No call or letter from the property owner was received within the time allowed, therefore I went to the property again on October 15th, 2024, and saw the cited violations had not been corrected. At the time, I photographed the property. Photograph accurately shows what I saw then, and is marked as county's exhibits 12 through 14. So there's the inoperable vehicle still on site. There's more trash and debris still on site. And then there's by the front door again.
Okay.
I request that all the county's exhibits be received into evidence, and based upon the testimony and evidence, I request that the respondent Holly A. Speakman be ordered to comply with the cited provisions of the Martin County Code by November 29, 2024, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violation continues thereafter. The county has incurred a cost in the amount of $575 conducting this investigation, and requests that the county be reimbursed this amount at the conclusion of today's hearing.
Okay, and just clarification, you're requesting $100 per violation?
Per violation, correct.
Okay, all right. Is that vehicle, do you know whether it's tagged? Whether it,
It appears that there is a tag on it. I don't know if it's,
okay, but it doesn't look like it's moved.
no, there's a flat tire, so it's not going anywhere at this point.
Okay. All right. Anybody here on behalf of Holly Speakman? Looking out, seeing no one, without objection, I'll accept into evidence the county's exhibits 1 through 14 in this case, based upon the evidence in your testimony. I will find that violations of 67.201.B, trash, and 91.34.A, generally inoperable vehicles, does exist or do exist on the property, and order compliance on or before November 29th, 2024, failing which a fine in the amount of $100 per violation per day will accrue, and I'll further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing, and it's so ordered. Okay, let's see, we've got one more. This is case number ENF 2024-080047, and the respondent is Lourdes Petit Noel. Nobody here in that case either. Okay, go ahead, Ms. Switzer, whenever you're ready.
My name is Kelly Switzer, and I've been sworn in. I'm a code compliance investigator for Martin County. The respondent, Lourdes Petit Noel, is not present. This case concerns a property at 1147 Southwest Spruce Street, Palm City, Florida, 34990, in Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Lourdes Petit Noel. A copy of the property appraiser's record of ownership is county's Exhibit 1. On August 2nd, 2024, I inspected the property. At that time, I observed trash and debris along with tall grass in the back and side yards. At the time, I photographed the property. The photographs accurately show what I saw then and is marked as county's Exhibits 2 through 4. So there's the trash and the tall grass in the back, along with the side along the house. 3 is more of the grass along the side of the house. And then 4 is just another angle of the trash. Based upon the investigation, I issued a notice of violation to Lourdes Petit Noel on August 6, 2024. The notice of violation is marked as county's Exhibit 5. In the notice, I cited the following Martin County Code violation, Section 67.201B, nuisance declared trash, etc., General Ordinances, Martin County Code, and Section 67.201A, nuisance declared weeds, undergrowth, General Ordinances, Martin County Code. The notice of violation, the respondent was given until August 26 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on September 24th, 2024, and is marked as county's Exhibit 6. The return receipt was not returned, therefore I posted the property and at the Martin County Administrative Building. The posting and the affidavit of posting is marked as county's exhibits 7 and 8. This is my posting, and this is my affidavit of posting.
All right.
Exhibits 10, 11, and 12 are actually mislabeled. They're supposed to be 9 through 11, so my apologies. No call or letter from the property owner was received within the time allowed. Therefore, I went to the property again on October 15, 2024, saw the cited violations had not been corrected. At that time, I photographed the property. The photograph accurately shows what I saw then and is marked as county's exhibits 9 through 11. There's more trash along the back of the house, over here.
All right, and this is Exhibit 9.
Correct. Exhibit 10 is the tall grass. And Exhibit 11 is going to be just more trash on the side of the house. I request that all the county's exhibits be received into evidence, and based upon the testimony and evidence, I request that the respondent, Lourdes Petit Noel, be ordered to comply with the cited provisions of the Martin County Code by November 29th, 2024, and if not in compliance by then, be required to pay an amount, in the amount of $100 for every day the violation continues thereafter. The county has incurred a cost of an amount of $575 conducting this investigation, and requests that the county be reimbursed this amount at the conclusion of today's hearing.
Okay, anybody here on behalf of Lourdes Petit Noel? Looking out, seeing no one. Without objection, I'll accept into evidence the county's exhibits 1 through 11 in this case. Based upon that evidence and your testimony, I'll find that violations do exist on the property as charged, and order compliance owner before November 29th, 2024, failing which a fine in the amount of $100 per violation per day will accrue, and I will further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing.
Thank you.
Ma'am? Okay. Let's see. Ms. Bradley. Okay, top of the next page, right?
Yes, sir.
All right, good. All right, so this is case number 15-00955457CE-1, Republic Consumer Lending Group, Inc., and it's a fine reduction request, and I see there's a stipulation and agreed recommended order. If you'll raise your right hand, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I'm smiling based upon the cast on your arm, but I'm not laughing at you.
You're fine.
Okay, whenever you're ready.
Okay. My name is Rachel Spradley, and I've been sworn in. I'm the nuisance abatement coordinator for Martin County. This case concerns the property located at 18230 Southeast Ridgeview Drive, Tequesta in Martin County. On June 29, 2016, an order finding violation was issued by the Code Enforcement Magistrate to Republic Consumer Lending Group Incorporated for Section 21.111 Protective Treatment, General Ordinances, Martin County Code. And Exhibit 1 is the property appraiser. Exhibit 2 is the original order that was issued. Compliance was required by August 1st, 2016. On May 16th, 2022, an affidavit of compliance with accrued fines was issued reflecting an outstanding fine in the amount of $208,300 plus cost in the amount of $575, and it was actually an affidavit of transition.
Okay.
We transitioned this property into an unsafe. This is the case that you heard a while ago.
Yeah, I'd say 2016.
No, actually, you've had this one a couple of times.
Oh, okay.
But staff has determined a lien reduction is warranted. The respondents were responsible for the violation, and the county brought the property into compliance by condemnation. And the respondents have offered to pay $20,857.50 to resolve the outstanding fines. And Exhibit 4 is their request for the reduction. And that concludes my testimony for this one.
All right, and the county is satisfied that the amount is fair?
Yes, sir, it's the 10% that's required.
Okay. All right. Okay. All right, so, without objection, I'll accept into evidence the county's exhibits 1 through 4 in this case. Looking at the stipulation, it does recite what you just testified to, Ms. Bradley, so I'm going to find that it is appropriate to grant the fine reduction stipulation, approve it. It is signed by Zachary Ullman, attorney for HSBC Mortgage, and by John Colando, Code Compliance Administrator on behalf of the county. And this is an agreed recommended order. It goes to the County Commission for approval. Okay. All right, next one is also a fine reduction hearing, and it is ENF 2019-020038. And the respondent is Republic Consumer Lending Group, Inc.
Same property.
Okay. And what do we got here?
My name is Rachel Spradley, and I've been sworn in. I'm the nuisance abatement coordinator for Martin County. This case concerns the property located at 18230 Southeast Ridgeview Drive, Tequesta in Martin County, Florida. Property appraiser is Exhibit 1. On April 17, 2019, an order finding violation was issued by the Code Enforcement Magistrate to Republic Consumer Lending Group, Incorporated, for Section 21.105 Pools, Swimming Pools, General Ordinances, Martin County Code, Section 67.201.A, Nuisance Declared Weeds, Undergrowth, General Ordinances, Martin County Code, Section 21.115 Roofs, Roofs and Drainage, General Ordinance, Martin County Code, and Section 21.111 Protective Treatment, General Ordinances, Martin County Code. So the original order is Exhibit 2. Compliance was required by May 31st, 2019. On May 16th, 2022, an affidavit of transition and accrued fines and costs was issued, reflecting an outstanding fine in the amount of $314,100 plus cost in the amount of $575. Staff has determined that a lien reduction is warranted. The respondents were responsible for the violation, and the county has placed the property into compliance by condemnation. And the respondents have agreed to pay $31,467.50 to resolve the outstanding fine. And the affidavit of transition is Exhibit 3. And then Exhibit 4 is, again, their reduction request. And that concludes my testimony for this one also.
Okay. All right, well, looking at the fine reduction stipulation, find that it does, in fact, reflect your testimony, and note for the record that it is also signed by Zachary Ullman, attorney for HSBC Mortgage, and by John Colando, Code Compliance Administrator on behalf of the county. And I do find it is appropriate to recommend a reduction of the fine to $31,467.50. In this case, it is recommended to the County Commission for approval. All right, another fine reduction request. This is case ENF 2022-110663. Respondent is Alicia Parrish.
This one is the one we're waiting for.
Okay, go ahead and just,
Okay. My name is Rachel Spradley, and I've been sworn in. I'm the nuisance abatement coordinator for Martin County. This case concerns the property located at 1843 Southeast Lafayette Street, Stewart, in Martin County, Florida. On June 21st, 2023, an order finding violation was issued by the Code Enforcement Magistrate to Alicia C. Parrish for Sections 105.1 FBC permits when incorporated by Section 21.1 General Ordinances, Martin County Code. So the property appraiser is Exhibit 1, showing Mrs. Parrish as the owner. Exhibit 2 is the original order that was put in place.
Okay.
Compliance was required by July 31st, 2023. On September 3rd, 2024, an affidavit of compliance with accrued fines was issued reflecting an outstanding fine in the amount of $39,900 plus cost in the amount of $575. And Exhibit 3 is the affidavit of compliance with accrued fines. Staff has determined that a lien reduction is warranted. The respondents were responsible for the violation. They brought the property into compliance and had offered to pay $4,075 to resolve the outstanding fines which have accrued. And Exhibit 4 is the request for reduction from Mrs. Parrish.
All right, so she's requesting $0, and that is not reasonable under the circumstances. I do find that the 10% amount of $4,075 is reasonable. So I'm going to accept into evidence the county's exhibits 1 through 4 in this case, based upon that evidence and your testimony, and even the request from the respondent. I'm going to find that the amount of $4,075 is reasonable.
She did request it up at the top. Mr. Nicoletti, if you look on the email, she replied.
Okay, I wasn't sure whether that was you or whether that was
No,
her.
that's from her.
Okay. All right. Yeah, I guess that's the county's banner that
Yes.
caution. Yeah, that just kind of threw me off.
It just shows it came from my email.
Okay. All right. Okay. So I'm going to go ahead and find that it is appropriate to recommend approval of the stipulation to the county commission and approve the order once I have the original in front of me.
Yes, sir.
Okay.
Thank you.
All right. Very good. And let's see, Officer Bush. Good morning.
Good morning, sir.
You raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
All right, very good. Let's see, we've got case number ENF 2024-070-119-01, and several respondents, James Harris, Carrie Wiley, Solomon Harris, Harris Ecker, Marie Bryant, and Willie Harris. Looks like this is it an estate or? Well, not necessarily, just a number of,
In probate.
oh, it is, okay, so it is,
The owners, for your honor, are subject to a determination of homestead order.
okay, all right, very good. Lots of folks here. Ms. Bush, whenever you're ready, you go ahead.
Thank you, sir. My name is Tamika Bush, and I have been sworn in. I'm a code compliance investigator for Martin County. The respondent, James Harris, Carrie Wiley, Marie Bryant, Ecker Harris, Solomon Harris, and Willie Harris, is not present. This case concerns the property at 8566 Southeast Mars Street in Hobe Sound, Florida, 33455 in Martin County, Florida. This case was not generated from an anonymous complaint. And according to the official records of the property appraiser of Martin County, the property owner is James Harris, Carrie Wiley, Marie Bryant, Ecker Harris, Solomon Harris, and Willie Harris. On July 12, 2024, I inspected the property, and at that time, I observed overgrowth, trash, and debris. At that time, I photographed the property, and the photographs accurately shows what I saw then, and it's marked as county's exhibits 2 through 6. Exhibit 2.
What am I actually looking at there in 2?
And 2, it shows the overgrowth here. You can see some trash and debris, but mostly the overgrowth and just the property itself. So it's a full view of the actual property or the structure. Here's Exhibit 3, which is another angle of the property, which also show that there's trash and debris there, also the overgrowth here. There'll be a few other pictures with closer photos of the trash and debris. Exhibit 4, which now shows a close-up of it and the overgrowth, sir.
Okay. So it looks like it's kind of embedded in that fence line and
Yes, sir.
underneath the sea grape tree? Okay. Okay. 5, what are we looking at? Oh, broken fence.
And then that's more trash and debris. Based upon the investigation, I issued a notice of violation to Carrie Wiley, James Harris, Solomon Harris, Edgar Harris, Marie Bryant, and Willie Harris. On July 29, 2024, which is marked as County Exhibit 7. In the notice of violation, I cited the following Martin County Code. Section 67.201A, weeds, undergrowth, nuisance declared, general ordinances of Martin County Code. Sections 67.201B, trash, nuisance declared, trash, etc., general ordinances of Martin County Code. In the notice of violation, the respondent was given until August 12, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on September 24, 2024, and is marked as County's Exhibit 8.
Okay.
The return receipt was not received. The property in Martin County Administration building was posted on October 1st, 2024, and an affidavit of posting is marked as County's Exhibit 9. I went back to the property again on September 15, 2024, and saw that the cited violations had not been corrected. And at that time, I photographed the property. The photographs accurately shows what I saw then, and it's marked as County's Exhibits 10 through 15.
All right, you said September, you did what I did. Is it actually October 15th?
October.
Okay.
I'm sorry, sir.
Ah, me too.
Thank you.
I did the same thing.
Exhibit 10, a photograph of the overgrowth.
Haven't really changed any, huh?
Exhibit 11. Exhibit 12, it's a different angle of the same property. Exhibit 13, which is not changing. Maybe the same photograph of the same angle. Exhibit 14 is a closer photograph of the garbage, trash, and debris and overgrowth. Exhibit 15 is the angle of the actual property itself, or the structure. I request that all of the county's exhibits be received into evidence, and based upon the testimony and evidence, I request that the respondents, James Harris, Carrie Wiley, Solomon Harris, Edgar Harris, Marie Bryant, and Willie Harris, be ordered to comply with the cited provisions of the Martin County Code by November 29, 2024, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day for every violation for every day the violation continues thereafter. The county has incurred a cost in the amount of $575 conducting this investigation and requests that the county be reimbursed this amount at the conclusion of today's hearing.
Okay. Anybody here on behalf of James Harris, Kerry Wiley, Solomon Harris, Ecker Harris, Marie Bryant, or Willie Harris? Looking out, seeing no one. Without objection, I'll accept into evidence the county's exhibits 1 through 15 in this case. Based upon the evidence and your testimony, I'm going to find that violations as charged do exist on the property, and order compliance on or before November 29th, 2024, failing which a fine in the amount of $100 per violation per day will accrue, and I'll further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing.
Thank you, Special Magistrate.
Yes, ma'am, thank you. I'm just looking at, I see the order determining homestead status. In the case, okay. I guess that's fairly clear who owns it. All right, very good. And so ordered. Good. All right. Did I did announce all of that, right, on the record?
Sir.
Good.
Yes. Yes, you recited all the owners.
Good. All right. Wait a minute. How far did I get? I'm sorry. Lost my place. Did I say that I'm going to order compliance on or before November 29th?
Yes, sir.
Failing which? Okay, very good. Let's see, next case. Brandon Moore and Jermaine Moore. Okay, this is case number ENF 2024-08-0617, and the respondents are Brandon L. Moore and Jermaine Moore. And this is also your case, Officer Bush, whenever you're ready.
Yes, sir. My name is Tamika Bush, and I have been sworn in. I'm a co-compliance investigator for Martin County. The respondent, Brandon L. Moore and Jermaine Moore, is not present. The respondents have entered into a stipulation of agreement. This case concerns the property at 12311 Southeast Lantana Avenue in Hobe Sound, Florida, 33455 in Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Brandon L. Moore and Jermaine Moore.
Okay?
A copy of the property appraiser's record of ownership is County's Exhibit 1. On August 21st, 2024, I inspected the property, and at that time, I observed an accumulation of garbage, trash, junk, and debris stored on the property. I observed a water heater with no enclosure or permits for the enclosure and an inoperable vehicle. At that time, I photographed the property. The photographs accurately shows what I saw then, and it's marked as County's Exhibits 2 through 8. Exhibit 2 is some of the trash on the property. Exhibit 3 is a photograph of the structure and all of the garbage, trash, junk, or debris around it. This photo also includes the water heater without the enclosure.
Okay, so it's the building on the right
Yes, sir.
is the property, okay,
Yes, sir.
all right. Okay.
Exhibit 4 is the inoperable vehicle and then the front of the structure. Exhibit 5 is another picture of the structure and other trash and debris. Exhibit 6. Exhibit 7. Exhibit 8.
What we got in 7?
And 7, this is just a kiddie pool, but behind that, there's a stack of tires, vehicle tires here.
All right.
And then in vehicle 8, just another angle photo of the rear of the property, garbage, trash, and debris.
Okay.
Based upon the investigation, I issued a notice of violation to Brandon L. Moore and Jermaine Moore on August 26, 2024, which is marked as County's Exhibit 9. In the notice of violation, I cited the following code sections: Sections 105.1 FBZ permits, when required, incorporated by Sections 21.1 General Ordinances of Martin County Code, Section 91.34 generally inoperable vehicles, General Ordinances of Martin County Code, Section 67.201B, trash, nuisance declared, trash, etc., General Ordinances of Martin County Code, Section 67.201, weeds, undergrowth, nuisance declared, General Ordinances of Martin County Code. In the notice of violation, the respondent was given until September 23, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement. Upon doing so, compliance was not achieved and a notice of hearing was issued by certified mail on October 1, 2024, and is marked as County's Exhibit 10. The return receipt was not received. The property in the county's administration building was posted on October 1st, 2024, and is marked as County's Exhibit 11. On October 14, 2024, the respondent entered into a stipulation of agreement. The owner agrees to come into compliance with the cited provisions of Martin County Code by January 31st, 2025, and if not in compliance with the cited provisions of the Martin County Code by January 31st, 2025, will be required to pay a fine in the amount of $100 per violation per day for every day the violation continues thereafter. At this time, I request that all the county's exhibit be received into evidence. The owner has paid the agreed administrative cost of $350.
Okay, let me just correct one thing. I'm looking at the actual stipulation. It does say $100 per day, not, so it's cumulative for all of them. However, note for the record, if you're in violation of one,
You're in violation of law.
yeah, so I am going to accept the stipulation and agreed order and approve the agreed order. The stipulation is signed by Brandon Moore and Jermaine Moore on behalf of themselves, and Tamika Bush on behalf of the county. Find that it's appropriate to enter the stipulation. Note for the record that $350 has been paid to the county order compliance owner before January 31st in this case. And it's so ordered. Okay. All right. One more. It's case ENF 2024-080619, and the respondents are Herman Garcia and Edward Garcia Cordero. And whenever you're ready.
My name is Tamika Bush, and I have been sworn in. I'm a code compliance investigator for Martin County. The respondent, Herman Garcia, and Edward Cordero Garcia, is not present. The respondent has entered into a stipulation of agreement. The case concerns the property at 8376 Southeast Alamanda Way in Hope Sound, Florida, 33455 in Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Herman Garcia and Edward Cordero Garcia. A copy of the property appraiser's record of ownership is County's Exhibit 1.
Okay.
On August 21st, 2024, I inspected the property, and at that time, I observed an installation of pavers with no permits. At that time, I photographed the property. The photographs actually shows what I saw then, and it's marked as County's Exhibit 2. A permit screenshot screenshot is marked as County's Exhibit 3, which indicates that there was no permit for the pavers or paver driveway. Based upon the investigation, I issued a notice of violation to Herman Garcia and Edward Cordero Garcia on August 27, 2024, marked as County's Exhibit 4, and in the notice, I cited the following Martin County Code violation, Section 105.1 FBC permits, when required, incorporated by Section 21.1 General Ordinances of Martin County Code. In the notice of violation, the respondent was given until September 17, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on October 1st, 2024, and is marked as County's Exhibit 5. The return receipt was not received, and the property in the Martin County Administration Building was posted on October 1st, 2024, and an affidavit of posting is marked as County's Exhibit 6. On October 14, 2024, the respondent entered into a stipulation of agreement. The owner agrees to come into compliance with the cited provisions of Martin County Code by January 31st, 2025, and if not in compliance with the cited provisions of the Martin County Code by January 31st, 2025, then be required to pay a fine in the amount of $100 per day for the violations, for each violation, for every day that the violation continues thereafter. At this time, I am requesting that all the county's exhibit be received into evidence, and the owner has paid the agreed administrative cost of $350.
Great. All right. So I'm looking at the stipulation. It recites exactly what you just testified to. So without objection, I'm going to accept into evidence the county's exhibits 1 through 6 in this case. It does require compliance on or before January 31st, 2025, failing which a fine in the amount of $100 a day will accrue. Note for the record that $350 as stipulated has been paid to the county in costs. And the stipulation is signed by Herman Garcia and Edward Garcia Cordero on behalf of themselves and Officer Bush on behalf of the county. I'm going to find it appropriate to enter into the agreed order in this case. Okay,
Thank you, Special Magistrate.
thank you. All right. Let's see, we've got one other matter, and that's the set of minutes for the September 18th, 2024 code compliance hearing. And I have reviewed those and can approve them at this time. Note for the record that they are signed by Jillian Collane, who happens to be here today. Unusual to have our staff recorder with us. And John Colando as code administrator. Okay, good. Anything else to occur? We do not have a November hearing. So the next hearing is in December. Let me see if I can come up with a date. The 18th of December, I'm being told. Okay, great. All right, so we will see you on December 18th. Thank you very much. We stand adjourned.